Okay, we are going to go ahead and get started. It's 12:01. My name is Mary Pat Coe. I'm from the Court Improvement Project. I just want to welcome everyone to our legislative review of our last session in the legislature. Thank you all for attending. We really appreciate you attending our webinar, as well as thankful for our experts who are on our panel. While this hour and a half is not pre-approved yet for CLE, we don't have a problem getting that approval. We just don't have a number yet. So we will get that number out to everyone as soon as we can. We apologize for not having the number like we usually do. This is being recorded and it will be out on our YouTube channel. If for some reason you need to hop off, or if you were late getting on, you can always go to our YouTube channel, probably sometime next week when Tracy gets it out there. Please put questions that you have in the chat and we will keep our eye on that and try to get all those questions answered for you. Just a brief overview of CIP for people who haven't been on here before. We are the Nebraska Court Improvement Project. We are federally funded. What's unique about our Court Improvement Project from other states is that we have our Through the Eyes teams in all of our districts. Members of the teams are multidisciplinary teams. They're judge-led, and they look at their community and their juvenile court system and see what they can do to help improve that for all of our children, youth, and families that live in their area. They do this by holding different events, such as any sort of education in their community. They might do foster care recruitment. So anything that they think will have an impact on their community. What we do in our main office in Lincoln is we do a lot of educational things for stakeholders in juvenile court. We look at systemic issues and we try to make an impact on just the experience for families, youth, and children in our court system. We just try to make it better for them because that's what we're all here to do. So I am going to jump in and introduce all of our experts. We have Jeannie Bradner, who is with the Administrative Office of Courts and Probation. Elizabeth Einen-Kokerda, who is a managing attorney at Education Rights Council. Sarah Helvey, who is a staff attorney, and she is the director of the Child Welfare Program at Nebraska Appleseed. And Laura Offner, who was with Health and Human Services. She is the deputy director of policy and their legislative services. And we have Judge Stevens, who is with Douglas County Juvenile Court, as well as Bree McClartley, who is deputy county attorney in Dodge County. Let's see, if you could go to the next slide, Tracy, that would be awesome. And to start us off, we're going to start with Judge Stevens. Oh, and just before, sorry, Judge, just before you start, I want to just do my disclaimer. I did the slides, not the speakers, so any mistakes are mine. Also, as everyone knows, this was kind of an unusual session. So the bills that are going to be talked about, our experts have pulled out of those huge bills what will impact juvenile court. So like LB 50 has more in it than what you see on the slide right now. So if you want to see what else has in it, you will have to go and read the 100 pages. So with that being said, Judge Stevens.
Thank you, Mary Pat. Good afternoon, everyone. Yes, as Mary Pat said, they are huge bills, and I just chuckled a little bit. I can tell you LB 157 was entitled A Bill Relating to the Law, which is exactly what it is. And every kind of criminal or juvenile law you could imagine is in there. And LB 50 is a bill for an act relating to the administration of justice in all of the courts also. They are each over 30 pages long, but if in the introductions, you can identify where the statutes are that you want to address and look it up pretty quickly. So this morning, as our slide says, I have rather than using an LB reference, I have decided to speak from the statute that was amended, try and make my presentation short and as user-friendly as possible. So in LB 157, I will tell you statute 43-286 in the Nebraska Juvenile Code has been amended. That statute is, I'm just going to read the title to you so you will have an idea of everything that it encompasses, and it had one small amendment. It's in regard to juvenile law violators or juveniles in need of special supervision. Also relates to disposition in regard to those use and violations of probation or supervision orders by the court, the procedures related to those things, discharge from juvenile court, notice, hearing, and individualized reentry plans for those youth that are would be returning from YRTC. And in that statute, a section has been added or amended. Section 6 has been added to create an opportunity for youth who is on probation to make a motion to have their probation modified. I'll read the language to you. It states as follows: except as provided in subdivision 6B, which we will get to, of this section, the court shall not change the disposition unless a court finds that the juvenile has violated a term or condition of probation or supervision or an order of the court, and the procedures in subdivision 5B of this section have been satisfied. We all know that. So that has not changed. This is the only exception to that. Subsection B of section 6 reads, upon a motion of the juvenile, the court may modify the terms or conditions of probation or supervision, or modify a dispositional order if all parties stipulate to the particular modification. So, which references the specific change in the order. Not that it can be modified, but everybody has to stipulate to the specific change. And the juvenile has consulted with counsel or has waived counsel. Any waiver must be particular to the modification, so specific to the modification having been done, and will comply with section 43.3.102. Don't need to worry about that right now. Then after subsection 6, numbers were changed to adjust to this addition. But in a nutshell, it now allows a juvenile to make a motion for a change of the terms and conditions of probation or terms and conditions of disposition. The difference between those two things for folks who aren't familiar with it is a juvenile can be placed on probation once a case has been adjudicated, but it's also possible that the court can continue disposition from time to time and change orders or modify them before a child is officially placed on probation. That's why that distinguishing language is used in the statute. All right, also, section 43.279 was modified. Section 43.279 is in regard to juvenile law violators or juveniles in need of special supervision and their rights in the proceedings. The modification in 43.279 was, or added, a subsection G right after right of appeal. I misspoke. Subsection G is right of appeal. So right after a court right after the rights advisory and the rights delineated in 43.279, it appears from the legislative bill that this language will be added. That language is, after giving such warning and admonitions, the court may accept an in-court admission or answer of no contest. So this section of the bill adds the option for a no contest plea for juveniles, along with an admission. 43.279 and 43.280 have both been modified, adding the language or an answer of no contest right after the word admission. So those are now recognized statutorily as two of the pleas that a juvenile can make. I found this all very interesting because the Supreme Court had been very clear about no contest not being an option for juveniles in juvenile court for some time. But I also found out that there are, courts all over the state that do allow no contest pleas. And in my exploration, I also found that the county court judge's bench book had no contest as an option for juveniles in juvenile court as a plea option. So I had no surprise that this was coming. And also it appears to be an expedient option if juveniles don't want to admit the allegations are true, but don't want to contest the allegations either. And so that's been approved by the legislature. As a juvenile court judge, I appreciate the expedience of it. I will be interested to see the effect of it. It's often so hard for youth between a certain age to get a picture of personal responsibility. Those ages, as we see them, hit about 12 up to 17. At about 17, I'm watching young men and women really start understanding their personal responsibility in their lives. But before that, not the same way. And it's just related to maturation and brain development, I think. But so I will be really interested to see if having a no contest plea option has any relationship to successful outcomes in probation. And then in, 43-108, a subsection was added that reads as follows. And I'm reading these because I want to use all the right language rather than summarizing correctly. I think right language is pretty important. It added a subsection 10 that states, any juvenile court order that places a juvenile on electronic monitoring shall also state whether the data from such electronic monitoring device shall be made available to a law enforcement agency immediately upon request by such agency. For any juvenile subject to supervision of a probation officer, the name of the juvenile, the name of the juvenile's probation officer, and any terms of probation included in the juvenile court order otherwise should be open for inspection and shall be provided to the Nebraska Commission on Law Enforcement and Criminal Justice, which shall provide access to such information to law enforcement agencies through the state's criminal justice information. So the law now requires that when a juvenile court judge places a juvenile on electronic monitoring, an order shall state whether the data from that electronic monitoring device shall be made available to law enforcement agency by passing that information on to the Nebraska Crime Commission on Law Enforcement, along with the additional information of the probation officer and those things. So it will be interesting to watch and see how that unfolds. All right, that's my part.
Thank you, Judge Stevens. I see more people are on than when we got started, so I just wanted to put a reminder out there that this is being recorded and it will be on our YouTube channel probably next week. And next up on our expert panel is Bree.
Yes, hi, can everyone hear me? Yeah.
Yes.
Okay. So I'm covering some of the same things that Judge Stevens talked about, but kind of from a different perspective with the County Attorneys Association. So we did also to kind of talk about the no contest plea. That was one of the bills we came in support of. And I think really Judge Stevens pretty hit it on the head from our point of view. It's for the expediency purposes. From a county attorney's perspective, we're trying to get that kid to a point of adjudication so that services can officially start with probation. And so that's kind of where we see the no contest as being just another tool in our toolbox to negotiate, to talk about plea agreements, and to, if the kid is going to be on probation, getting them to those services sooner. So definitely for us, it was an expediency basis for why we supported the legislation. And we also were hearing across the counties, across the state, that there was a discrepancy and that some counties were accepting and some weren't. So I think overall, just consistency is another kind of byproduct of having this officially be in the statute, so that all juveniles are being treated equally across the state. So the electronic monitoring information of law enforcement, this has been something that has been tossed around a lot, and a lot of the issues we've had is as county attorneys is we've had kids that either have gone missing, or we have kids that unfortunately committed new law violations, and law enforcement seeking the electronic monitoring information, the data, the GPS actual like coordinates to see like, well, was that kid there? Or where is the kid if they're missing? And we've run into some issues with an AG opinion that said, you can't just ask for that. It has to go through a subpoena process and then a warrant and all this official court hearing to release it. And obviously for investigations for law violations, okay, yeah, we can go through that process. But for kids that are missing, that really does decrease the ability to use that type of GPS monitoring to try and find missing youth that are on probation or that have absconded. So that's one of the reasons that we have kind of kept an eye on that and have worked with state senators and stakeholders about making those law violation changes. Specifically the information for the CJIS. So CJIS is the Criminal Justice Information System. It's something that county attorneys as prosecutors have access to. It's also something that law enforcement have access to. And so what we kind of noticed is they really have to dig deep to figure out, who's the kid's probation officer, who can they contact if they have a run-in with the juvenile. So it's information that is available, but you kind of have to like go and find the order and see who is present in court. And that must be their probation officer, assuming they're covering for someone. So it's a way so law enforcement know they're on probation. They have these terms, which maybe include like the ability to search for drugs and who their probation officer is, so they can make contact and say, hey, I have your kid. What do you want me to do? What's going on with this kid? So that's some just basic information to make those interactions with law enforcement, I guess, less tedious, or at least so they have more information about what's going on with that kid in their current probation case. So this is all part of LB 50, which I'm sure someone already talked about as being like a massive, massive bill with all these other bills kind of peppered into it. And so one thing that it's not quite juvenile court specific, but it's something as prosecutors I wanted to flag. And that is there's a lot of changes and kind of nuances about sentencing, about post-release supervision, as well as parole eligibility for parents. And so this might affect juvenile court because sometimes we have parents that early on in the case, they maybe have a criminal law violation that's maybe related to the removal. They get sentenced, they have their criminal charge kind of handled. And we kind of look at what is that? Are they going to jail? How long are they going to jail? What's their parole? When can they possibly get out? And sometimes that does drive a lot of case progress, or whether a case plan can even be worked with the parent. So for defense attorneys and guardian ad litems, it might be really helpful to understand maybe what some of those changes are, because that might modify what services are available to the parent while they're in jail, but also how soon can they get out, and is reunification possible. So it's just really important to kind of know that there are some changes coming and how they might impact case progression on the 3A side. So LR 245, this is a legislative resolution. So it's an interim study essentially, and it really is looking at juvenile detention costs and updates. And what we've kind of found in my conversations with other county attorneys is there's a huge difference in what's available at certain detention facilities. How can we get people in or out, or services to them while they're there? We in my jurisdiction have struggled a little bit with making sure that their educational services are still being provided. So I think there's so much to unpack in LR 245. And with any interim study, it really depends on who the chair of the committee is, and if there's a really kind of a vigor by the introducer about wanting to look at this. So I'd encourage anyone that has interactions with their detention facility, has juveniles there, have thoughts about ways we can make them better, or anyone footing the bill and having to pay the cost. I know in my county, that's what we do if they're pre-adjudication, to definitely reach out to Senator Vargas's office and say, hey, I have information I'd love to share with you. Because the more information or people he can identify as these would be a great testifier, this is great research, this is great data, the more it's easier for him to kind of put together a plan and show to Senator Wayne, like, hey, there's a need for a discussion on this. A lot of people are interested. We need to have a hearing. And we need to invite these people to come testify. So definitely, if this is something that you in the juvenile court system are working with, or have juveniles that are there, definitely reach out, think about what you'd like to discuss or what can be discussed. It's a pretty broad interim study, so I think everything's really on the table. But I know in my county, we just renewed all of our contracts and fee agreements with the different juvenile detention, so we don't have our own. So I'm definitely going to be like, yeah, there's some huge discrepancies in payment. How much it costs to have each kid. We're having a huge shortage about possible beds. There's a lot going on. So definitely, if you have an opinion, you should definitely let Senator Vargas know that you're interested in talking about it. The next interim study is one I think we've talked about on this panel pretty much since I joined it. This is about truancy. And so Senator Conrad introduced the truancy bill that was pretty much a copy of what Senator Pansing Brooks had been introducing the last couple of sessions. So it's still on general file. It's just kind of hanging out there. So I think this is for her to kind of have an avenue for some of the stakeholders to come back to the table and talk more about what do we need, and what really are we kind of arguing about, and where is the consensus. I think Judge Stevens just said it perfectly that it's important to look at the right language. And here you see in this description, it talks about excessively absent as one, or truant, and they are really kind of different things. Truant is, to me, or how I interpret it as, is that is a kid that is giving the middle finger to the school saying, I'm not going, you can't make me. And I see that more as delinquent behavior. And that's kind of the county attorney's position, is that that's something that can be solved with probation services, because we're talking about poor decision-making and delinquency. But excessive absenteeism, I think everyone that works in the juvenile court system knows that sometimes that is so much just economic issues that the family's facing, and lack of support within the community, or even transportation. And is that something probation can solve? No. That's definitely a whole different, but does that flip to the other side where HHS has to get involved? Maybe not. So I think there's a great conversation to be had about, let's narrow the focus about when does a juvenile court jurisdiction actually need to happen? Truant because of delinquent behavior, excessive absenteeism because of educational neglect. And then there's a bunch of families in the middle that are getting caught up in the system. But do we have the resources within the community to support them? I don't know, but that's kind of a larger question I think we need to start talking about, and really being careful about the language we're using when we're talking about juvenile court involvement, juvenile justice for truancy, or juvenile dependency or neglect for educational neglect. So just really interesting conversations to be having about interim studies. Definitely, I think both of these senators really want the discussion, so possible solutions can kind of come out of it. So definitely reach out, talk to the senators and their staff about it. One thing that's not on the list, but I did just kind of want to highlight, there was a bill this year about raising interpreter pay. It was actually incorporated into the budget, but then there's a line item veto, so it didn't happen. And almost immediately after that, at least on my side of the state, we had all of our court interpreters go on strike, and it brought our courts to a screeching halt. Some of the things were able to be continued out, and we luckily were able to come to a resolution, and our interpreters who we love dearly are back. But I had a really scary moment where I had a removal and the mother was Spanish speaking, and I'm like, I don't know if I can have this hearing, but I definitely know it's not safe for the kid to return home. And it was creating a due process issue that luckily we were able to resolve, but that could be a really scary thing if we don't continue to support all of the people that work in the juvenile court system with us. I mean, caseworkers, interpreters, everybody. So it was a small bill. It kind of felt like I think we just sent a letter like, yeah, that's, of course we'll pay them more. Not supporting it and not advocating for it more strenuously really had some damaging results. So definitely just always something to keep in mind as you're looking at these bills. You might think, of course we're going to do it. That's a no-brainer. Sometimes it's not. And then sometimes it has real life consequences, especially in preventing equal access to justice. So just a few things that I flagged from the session that were interesting and that we kind of saw play out even after the session ended.
Thank you, Bree. And now we're going to move on to Sarah Helvey.
Hey, hi, everyone. I want to talk about a portion of LB 50 that was originally introduced by Senator George Duncan as LB 14. And this is a reintroduction of a bill that was previously introduced by Senator Pansing Brooks and Senator Bowles before that, introduced many times to expand the Bridge to Independence program to include a subset of the juvenile justice population, specifically those who need the support of B2I because they don't have a home to return to and may face homelessness. For Appleseed's perspective, this was a big victory. This population was part of the original bill 10 years ago, but was amended out before the bill passed. And so it's something that we've been wanting to get back to since the very beginning. So many years coming. I want to clarify that the bill does not expand B2I to all JJ youth. It's just a subset. And the bill sets out a process to identify that subset. So first, the Office of Probation is required to identify potentially eligible youth. So those who are in a court-ordered placement the 6 months before they turn 19, and then probation is required to provide those youth with information about the program. Then any party to the juvenile court's case or the court on its own motion can request a hearing during the 6-month time frame for the juvenile court to consider whether it would be contrary to the youth's welfare to return to their family home, and if it's necessary for the youth to remain in their out-of-home placement. And this is really intended to ensure that youth aren't kept on probation unnecessarily in order to participate in B2I. And again, that the program is targeted for youth who might otherwise be at risk of homelessness. And then then the bill sets forth factors for the juvenile court to consider in making that contrary to welfare determination. That's whether the youth is at risk of homelessness at the closure of the juvenile court case. The youth is disconnected from family supports that would assist them in transitioning to adulthood, and that the Office of Probation has made efforts to return the youth to the family home prior to the youth's 19th birthday. A new addition to the bill this year was that a youth with a current pending motion to revoke probation before the court at the time of the hearing is not eligible for probation. Eligible for the program. Let me just repeat that. The juvenile with a current pending motion to revoke probation before the court at the time of the hearing in that 6-month period is not eligible for B2I. And then the bill provides that the juvenile court make a necessary finding that they're eligible for a B2I. And at that point, there's a transition over from the Office of Probation to DHS. Office of Probation is required to notify DHS within 10 days. And then DHS is required to provide information to the young person as soon as practical thereafter and prior to their 19th birthday, so that the young person can still decide if they want to voluntarily participate in B2I, since it is a voluntary program. Youth with juvenile justice cases, this new population has to meet all of the other requirements of the B2I program, including participating in an education or work activity, unless they have a medical condition or a barrier to education or work, and meet the Nebraska residency requirement. And then once they're in the program, the benefits and the responsibilities are exactly the same, including monthly visits with their caseworker and annual court hearings. One important thing to note is that there was an amendment to the bill that delayed the effective date to January 1st, 2025, and then also requiring regulations to be promulgated by the department by October of 2024. So we were disappointed a little bit that young people won't be able to access the program until that time, but it does permit the opportunity to implement the program really well, given the need to collaborate between HHS and probation for this program. And I'm sure we'll be doing some trainings as well, given the role of juvenile court and attorneys in the program. So again, we're just really excited about that. More to come prior to January 1st, 2025. I also wanted to mention, that's on the list, one interim study that we'll be working on, and that's LR 143. It was introduced by Senator Brewer. The focus of the study is ICWA, to review applicable court precedent related to Nebraska ICWA to determine whether a legislative response is appropriate to clarify the law. It also is focused on looking at disproportionality and how state courts interact with tribal representatives and tribal courts to recognize the sovereignty of the tribes. It's a really broad study. To be real honest, I think part of what was in the back of some folks' mind was contemplating a bad ruling from the U.S. Supreme Court in the Brackeen versus Holland case. There's still plenty of work to do on ICWA at the state level. But as you hopefully are all aware, that case had a surprising 7-2 victory to uphold ICWA at the U.S. Supreme Court, which is probably also a separate CLE someday. But that with the upholding of ICWA, I think that interim study will probably look at some of the other issues in terms of just the state level implementation and the interaction between state courts and tribal courts. So if you have input in that, reach out to Senator Brewer. And with that, I'll turn it over to the next presenter.
Thank you, Sarah. Next up is Jeannie Bradner.
Good afternoon, everyone. Thank you, Mary Pat, and all of the CIP staff for organizing and facilitating this webinar today. I have the privilege of going after some amazing experts, which is very helpful because a lot of my information has already been stated. So thanks to all of you who presented before me. Sarah, I'm really glad we got to talk about the Bridge to Independence. When we were on our planning call, I said that's really something Sarah needs to talk about. And Sarah did not give herself enough credit for this. She has been instrumental in the work over the last 10 years in order to expand the Bridge to Independence for a subset of juvenile justice youth. And I would also be remiss if we didn't mention Jenny Scala from Nebraska Children and Families Foundation. Again, as Sarah said, 10 years ago, this venture started. And so we're definitely glad to see that, and even with the delayed implementation date. So I don't have anything more to say about the Bridge to Independence. Sarah did a fabulous job covering that. LB 799 provided for an additional county court judge in Judicial District 9. That is the Grand Island and Kearney area. That was related to a number of court cases, juvenile court cases that were on the rise there. And so we are grateful to get some relief to those judges in Grand Island and Hall County, and also the other judges that have been covering to help support that caseload numbers that have increased over several years there. So that will be in the works and transpiring probably around the bill implementation. And I don't know if anyone said this yet, but bills that were passed, unless they have an emergency clause, are set to implement. I believe it is September 2nd is the date on that. So around that time, we will be seeing a new county court judge there. LB 705 is, it was born out of a legislative resolution and a lot of great work from Senator Arch, as well as Senator Walls, who are really interested in what does the educational data and information sharing look like in the state of Nebraska. So this bill provides an opportunity for a contractor to be hired who has some expertise in this area to help the Department of Education, who is the lead on the project, Health and Human Services, as well as the Administrative Office of the Courts and Probation, to maneuver what is the education data available, what are the federal laws associated around that, what are the state laws associated around that, and are there mechanisms that can be developed in order for that information to flow for those parties that have a right to know or need to know about the educational information, including the youth and the families themselves. So this wasn't just about system partners, but this is with youth who have high mobility, youth and families that have high mobility. They don't always have access to their records and history. And so there's a lot of things that can get lost in those transitions in terms of their educational records and credits and where things are at. So I think Senator Arch was really surprised to learn that the work that the probation officers do to gather educational information is hand done, is very labor intensive, is going directly to the school, waiting for forms to come back, getting releases from parents. And so looking to see if there are some provisions allowable in the law that would help expedite that sharing and critical information for parties. Again, like I said, right to know, need to know, and within the provisions of the law. Finally, the last one, and I know Bree already spoke about this one a little bit too, but maybe just from a little bit of a different perspective, LB 245. And I will remind that is a study to examine the juvenile detention cost. And this was born out of essentially a contract dispute that is still current with our largest facilities in the state, Lancaster and Douglas County, who gave notice to probation, and it was solely on the rate provisions, the rates, and asking for significant rate increases to what we've paid in the past years. And so again, because that has a legislative impact and appropriations impact, Senator Vargas did introduce the study to take a look and say, what can we surmise from what's happening and the cost of detention and everything that goes into that? And then do we have the legislative support, if there is indeed an increase of a high dollar amount, the legislative support to be able to have those funds available in our budget. I think that's it for me. So thank you.
Thank you, Jeannie. And now our next expert on my list is Elizabeth.
Thank you, Mary Pat. Okay, so I am managing attorney of Education Rights Council. So I look at things generally from an education perspective, because one of the things that we try to do is make sure that kids, for example, in the system, whether they're in detention or not, are getting the education that they need. So LB 705, as everybody has said, is a massive bill that has a million different things in it. Okay, all education related. I'm going to try and focus on a few of those. The things I'm not going to focus on is all the requirements for programming and funding that have to do with behavior intervention, mental health, college pathways. There's a whole bunch of stuff over there with regard to teaching and college and increasing capacity to have teachers that I'm setting aside. The three things that I kind of want to focus on is the first one, as listed here, is what we're calling the Too Young to Suspend bill. One of the things that Education Rights Council has figured out, unfortunately, is that we have many children with disabilities that have gone unidentified. And what we do know is that suspension and expulsion has a disparate impact on the basis of race. What we haven't really studied very much, but this bill addresses, is that disparate impact is even larger on our babies than it is on our high school kids. And that's something that's really, I think, surprises all of us, is that we are literally suspending and expelling babies. So when there are behaviors or things that would result in that, that often is an indicia that we are not educationally meeting the child's needs. We want to catch that early, because we also see way too many children that they're in 7th, 8th, 9th, and 10th grade, and their educational need may not have been met, so they can't read, they have other issues, and that sometimes ends them in the system, whether it's from neglect or whether it's a delinquency. So what this bill basically says is you may not suspend or expel a kid, basically PK through 2nd grade. The second section that I'm going to focus on is FAFSA. And this is an interesting piece, which is what 705 does require is that every single child prior to graduation complete the FAFSA. There is an exception if children want to opt out, if they're over 19, or if they're adults, the parents opt them out in writing. I think that the major takeaway that I take from this, having helped many kids try to complete the FAFSA, is I don't know when the last time any of you did this. It's hard. And I think that basically this is just a way to ensure that we have supports so that what can be a daunting process gets some support for all families, which goes towards access towards equitable education, increasing access. The third thing that I wanted to focus on is special education funding, which is not listed here, but I think is very important. One of the things that happened in 705 is that we significantly increased the funding that is going to go for special education. Again, I think this is important because we see too often kids in the system that have not gotten the services they need. And perversely, that is because of the way we go about funding special education. In this state, we want to have kids included. So we actually have more funding for children who need limited special education than we do for kids that have more significant needs. So because we don't fully fund that in this state, it puts enormous pressure on school districts not to provide services. And again, what that ends up doing is harming our kids, and we see them coming into the system. So one of the benefits that I see out of increased special education funding is that we can potentially decrease the number of children in the system and or get them out of this off probation, successfully terminate probation more quickly. Option enrollment is also something that is critical here for juveniles, which is option enrollment rules have changed in LB 705. For those of you who are not familiar, option enrollment permits a child to go to a district other than their home district. And what we were seeing and having, again, a negative impact is many kids are struggling in one district, but they may do well in another district. Especially what we're seeing is we see this in kids within the system when they move from one school district to another. They may have more supports. But if you are a child that has a disability, whether that disability is physical, mental, emotional, anxiety, depression, PTSD, in a wheelchair, cerebral palsy, whatever that disability was, school districts were able to say that the child was not able to attend. They were able to put a blanket, no individual determination, just if you have a disability, no. And that frankly was discrimination on its face on the basis of disability, which both NDE and others recognized. That no longer is in place. There now must be an individual determination and reporting to the state as to when you do not permit a child with a disability to attend, what is the basis for that? So it doesn't mean that a very, very small district must take a very, very high needs child that increases their costs exponentially. But what it does mean is there's no blanket ability to just deny every child solely because they have a disability. The next one is, no box checked is simply, this is, you do not have to indicate whether you've been in, I'm losing this one. I think it's juvenile system when you're applying for college. So it's more access to equity in the post-secondary world in terms of application. Finally, student discipline. This basically changes multiple pieces of the Student Discipline Act. The reason it is impactful from the juvenile perspective is that we had sort of a disbalance. So we had a lot of rules about timeframes for when children had to either make appeals or get a particular notice, but we had lots of opening on the other side where we literally had children that were being decisions made about, for example, expulsion taking 2 months. So it was an inequitable way of approaching. The other thing that I think is important in this is, so we changed timelines. We also changed mandatory reassignment and independent hearing officers under the Student Discipline Act. There was a reference to mandatory reassignment to a different building. And what happens in school districts that are larger, they often say, you may never return to the building you left. And that has a chilling effect on a child's desire to really achieve because they want to get back to where they feel they belong. So there has to be a hearing now on any mandatory reassignment. Also, with regard to student discipline in the entire hearing process as to whether the child did what they were accused of doing and whether the school district followed appropriate due process, there are hearing officers. You must use a hearing officer. Prior to this bill, the hearing officers were employed by the very individual that was recommending suspension or expulsion. So if not a direct conflict, there was certainly an appearance of impropriety. Now, independent hearing officers may be requested by the family. I don't know that I need to say a lot more about LR 245 because everybody's talked about it, except to say that we in Education Rights Council also are very interested in this because it is in part focusing on education and what education does a child get in these various circumstances and the disparity in being able to ensure what federal and state law require, which is if you are already getting services from a school district, those services are to continue when you're, for example, in detention with specifically special education services. And we find that given how little we do in terms of tracking and paying attention to this, that we really need to ensure that children's rights that they already have under law are being met. So I too would encourage anybody that has an interest in ensuring that the education of juveniles when they are within the system and especially when they're detained remains consistent to take special interest in this particular LR. And that's all I have.
Thank you, Elizabeth. One more thing before I move on to Laura. Jeannie wanted me to make sure to remind that Juliet Summers from Voices to Children, her leadership also on B2I, she had also done a lot of work as well for the juvenile justice youth. So she didn't want to forget Juliet. Thanks, Jeannie, for reminding me about that. And next on our panel is Laura from Health and Human Services.
Good afternoon, everyone. Laura Opfer. I am over policy and legislative services for Children and Family Services. I'm happy to be here and bookmark this wonderful webinar. On that note, I just wanted to let everyone know we are working on B2I program expansion for the probation population. Our team is busy at work with that. And so we look forward to serving additional youth through that expansion. A quick note on 705, Jeannie did talk about this one, but the deliverable for that will be a report that NBE will have in December of 2014. So just to emphasize, the goal of that bill is that they will have a consultant who will help create the foundation for the data sharing system. And then on to LR 229, just wanted to hit a few points of what's in this legislative resolution. Marie talked a little bit earlier about what LRs are, for those who might not be familiar, but they can go a variety of different ways. And I'm not sure what the plans are for this one, but just wanted to high level share some of the components. So this LR is really looking at the lack of educational support services and obstacles for foster parents. There's a few different components in there. So looking at what educational support services would be beneficial for foster parents as they support foster youth in their home. And then what educational services could be utilized to support adoption. So I assume that they want to look at making sure our kids who are available or need adoption, that we're removing some of those barriers that relate to education. And then they're also looking at post-adoption education support services. How can we make sure that the family and the youth have the support that they need after adoption is finalized? And then the last piece of this also says, basically, in any other obstacles that foster parents face that are needed to support children. So it sounds like it's mostly focused on foster parents, foster youth, and education services. But there's also a piece there that may encompass any broader obstacles that foster parents face as far as resources and legal obstacles. That's all that I have.
Thank you, Laura. I'm going to give people some time if they have any questions to put them in the Q&A, and we can get some of those questions answered for you if you have any. While I'm giving you some time to do that, I just wanted to kind of put a plug in for a couple other webinars that CIP has coming up. One is about Central Registry, and that is on Thursday, July 13th at noon until 1. The other one is also in July. It's Intersection of Brain Injury and Juvenile Justice, and that is on July 27th, again at 12 to 1. Let's see. I don't see any questions in the Q&A. I just really want to, again, express my thanks to our panel here of experts. They really make this webinar what it is, and that's why our participants keep going up. Because the information they're able to share with you. So again, my thanks to them. I appreciate their time and their talents of sharing their information with us. Wait, I think we have one. Has LR 194 been discussed? LR 194, that is in our Q&A. You're right. That is a legislative resolution that's out there. It's an interim study to research through collaboration through stakeholders, ways to adjust juvenile justice reform. I don't know if any of my panel has any other information about that resolution, but that is all that I have about it. It seems very broad and a bit vague. But if none of the panel know anything, I'm just going to reiterate what Bree had said about if you have concerns or information, reach out. That's from the Judiciary Committee at Senator McDonnell, to reach out to his staff and share what information or what concerns or questions you may have. You never know what way these studies will go, or if no one shares any interest in them, if they'll even have a study. So again, just encourage you to reach out to the Senator McDonald staff. Let's see, I think we might have a couple more questions. From Pat, that the B2I legislation will take time. I don't know if any of the other bills, as far as I know, don't have any emergency clauses. So I think September 2nd is when they will take effect. Again, I'm going to rely on my panel of experts if I missed an emergency clause anywhere. I don't think so. They're pretty quick about pointing those out when they talk about changes in the law. So we're going to assume September 2nd is going to be our magic date on any law changes. Oh, thank you for the question. Somebody asked, what happens with the bills that did not make it out of committee? Are they held for next session? Yes, thank you for putting that out there. Again, this is the first of the two sessions. So any bills that are still in committee, any bills still hanging out there in general file, they will be out there for next year. So you're right, nothing's done yet. So we'll have to see what next session brings us. There'll obviously be more bills dropped, but the ones that are still out there, we'll see what happens.
Hey, Mary Pat, sorry to interrupt, but the one thing I should have said, and I think everybody would be pertinent, is for LB 705, which is all the education stuff that multiple people have talked here, that passed with an emergency clause. So all of that is effective immediately.
Thank you, Elizabeth. Any other questions? Okay, I'm going to give another minute if anybody's furiously typing out there. Oh, I'm sorry. There is a question about the central registry information. Will it be recorded? Yes, we will record that webinar as well. And again, it will be out on our YouTube channel. If you go out to the Supreme Court website and click on, let's see, I'm gonna make sure I tell you right, programs and services, find court improvement project over to your right side and click on the YouTube symbol. You should be able to find that out on our YouTube channel. I would give it at least a week to give Tracy some time to get that out there. Any other last comments from anybody on our panel before we let everybody go? I don't see any. I'm not seeing any other questions out there. Well, again, my thanks for all those attending. And again, my gratefulness to my panel. I really appreciate all your time. And we may have one more question out there before Carol said thank you. I appreciate that, Carol. All right. I guess as to legislative needs, we will see you probably around next February of 2024. Thank you.
Thank you.